Chief Judge J. Harvie Wilkinson III. It is difficult in some cases to get to the very heart of the matter, but in this case it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today, this has not been the case. As calls for impeachment of judges for decisions the executive disfavors and exhortations to disregard court orders sadly illustrate. It is in this atmosphere that we are reminded of President Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the President and the executive branch of government will support and ensure the carrying out of the decisions of the federal courts. Indeed, in our late executive's own words, unless the President did so, anarchy would result. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis, but it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. Chief Judge J. Harvie Wilkinson III.